My lord, I seek your lordship's indulgence in making a mention of unlisted item. My lord, this is a bail application which your
The
lordship...
application should go before the voting room number 2. With the other court, yes.
But, my lord, this has to be taken up by you because your lordship has already passed the order.
Okay. No, listed
My lord,
on Monday. On today, let's see. On Monday?
My lord, it's just a bail modification. You've already... My lord, your lordship has already granted bail. However, we could not execute the bail bond. So we came here again for the bail conditions modification.
Okay, listed.
Oblige.
If I may seek your lordship's indulgence in mentioning one unlisted item, FAO number, I filed this morning, FAO. The urgency is that the appellant is likely to be ousted from his house due to the order passed by the Deputy Commissioner, Champai. And the trial court was not inclined to entertain the injunction application. And at this stage, an order has been made for eviction of the appellant. And no notice has been served to him whatsoever. So if your lordship permits, it may be taken up at 2 in the afternoon.
Let's see.
Obliged, my lord.
For motion, item number 1.
May it pleases your lordship? I would like to bring to your lordship's attention that the respondent number 1 has retired and a new incumbent has taken an interim charge as the chief secretary. The name is the Shri H. Lalemoya. However, the petition was filed before the superannuation of the respondent, and no notice has been issued to all the respondents, my lord. And with your lordship's permission,
This is a
if
contempt petition,
yes, my lord,
isn't it?
my
Yes.
lord.
So,
With your lordship's permission, if I may be allowed to change the cause title and issue notice without filing any impleadment application.
okay, heard Ms. Valinta Dimpoy, learned counsel for the petitioner, who submits that she may be allowed to make certain changes in the cause title filed in the instant case. Praise allowed. List in the next week.
Much obliged.
Admission, item 2 and 3.
May it please your lordship.
Yes,
Lordship, pursuant to the last order, my lord, the state is supposed to file an affidavit.
yes. So have they filed?
Your lordship, we are yet to file the affidavit because your lordship, the higher power committee is yet to send in their report. So that is why 2 weeks time may be granted to file the affidavit, your lordship.
Well, you have to give them some time.
My,
Yes, Mr. P.D. Nair, learned counsel for the petitioner, is present, along with Ms. Lalnum Lui, learned government advocate for the state respondents. The learned government advocate has prayed for further time to file their counter affidavit, which is not objected by the learned counsel for the petitioner. Yes, Ms. Zainam Sangpui, anything to mention?
Not in my lord. I already filed my opinion.
Okay. In view of the above, list after 2 weeks.
Much obliged, your lordship.
if it is not inconvenient, may I pray for?
On, you want a date,
My
on?
lord. My lord, could it be just before the vacation?
So give me a date.
My
On
lord, 12th or 13th of December?
13th.
13th, my lord.
Okay, on 13th. Yes.
Deeply.
Item 4.
My lord, pleadings have been completed and now it is for admission hearing. However, my senior is out of station today, so if the matter may be fixed after a week for admission hearing.
Today is also admission hearing, Lordship.
Anyway, both the parties are duly represented by the learned counsels. It is seen that pleadings are complete. List for admission hearing.
Can we
When?
fix that, Lordship? Because this now
On,
case is...
on, give me a date. When will you both be available?
Can we have it on Thursday, Lordship?
The date
21.
on 21/11/2020. Yes.
Item 5.
My lord, for the respondent number 3, then I may be permitted, I may be granted another 3 weeks' time for filing my affidavit.
Yes. Heard Ms. Zainab Sangui, learned CGC. For respondents number
3,
3, the learned CGC has prayed for further time to file their counter affidavit. It is seen that none appeared for the petitioner. In view of the above, list after 3 weeks.
oblige.
Item 6.
Your Lordship, we have already filed the rejoinder affidavit, but respondent number 1 has failed to file their affidavit till date.
Who is respondent number 1?
My lord, for the respondent number 1.
CGC, yes.
My lord, I didn't receive any instruction from the concerned department.
So are you going to file or not?
My lord, it's difficult to say whether we'll be filing or
We'll give
not.
you a final chance. Okay, then.
Yes,
we'll
my
let you
lord.
know.
Your Lordship,
Any order, my lord? Your
Your Lordship, they are given several final
Oh,
last
yes, we'll give
chance.
them a final chance, isn't it? Miss
Lilian Puikyangte.
Lilian Puikyangte, learned counsel for the petitioner, is present, along with, yes, Mr. Samuel, you are for?
2 and 3, madam.
Mr. Samuel L. Sankar, learned counsel for respondents number 2 and 3. And
State this
Ms.
lordship, respondent number 4.
Swami, learned government advocate for respondent number 4. Stop then. Ms. Zainab Sangui, learned counsel for respondent number 1, submits that she has yet to receive instructions from the respondent. In view of the above, considering the fact that this matter has been kept pending, awaiting for response from respondent number 1, this court find it fit to give final chance to respondent number 1 to file their counter affidavit, if any. List after 3 weeks.
Yes, my lord.
Obliged.
Item 7.
My lord, as the leading counsel, Mr. Tila Zekima is having some personal difficulties. May the matter be kindly taken up on next Thursday
What is the stage for admission hearing?
for admission.
Pleadings are complete?
Yes, my
Yes,
lord.
Your Lordship.
It is seen that the matter is fixed for admission hearing today. However, mention is made on behalf of Mr. Lalfak, Pagswal or Fakoma?
Lal Fakoma.
On behalf of Mr. Lalfakoma, who is submitting that the leading counsel for the petitioner is not able to appear due to some personal difficulties. In view of the above, let's this matter again on,
Thursday.
what's Thursday's date? Give me a date. What's
Three-
Thursday?
14.
On 14/11/2024 for admission hearing.
Oblige.
Item 8.
Yes. What is the state? Affidavit in opposition.
Yes, Your Lordship. We'll be filing within a week. We've received the comments, madam.
Mr. Samuel L. Sankar, learned additional AG, appearing for the state respondents, submits that they will be filing their counter affidavit within a week since the required instructions have been received. In view of the above, list after 1 week.
Obliged, madam.
Item 9.
Your Lordship, I'm appearing on behalf of the state's respondents, and we have received the Parawise comments. However, the affidavit is under preparation. Therefore, a week's time may be granted to file the affidavit, Your Lordship.
Yes, parties are represented by their respective counsels. Ms. Lalnun Louis, learned government advocate, has prayed for further time to file their counter affidavit. What is the reason? Why haven't you filed it today?
Your Lordship, we just received the Parawise comments last week.
Mentioning that they have received the Parawise comments and need some time for preparation. In view of the above list, yes, after 2 weeks,
Yes, Your Lordship.
Item 10.
Much obliged, Your Lordship.
My lord, I'm appearing on behalf of my senior, Mr. Bilal Ramenga. LC original
One, 3, 5, 8, 9, and 10. I may be granted 3 weeks time for filing my affidavit, my lord.
whenever we see Ms. Zairam Sankwe, the impression that comes into mind is further time will be prayed for. What's going on? Do you actually contact the respondents? Do you have their phone number? Do you take steps to inquire, or you just send the notices and then wait for respond from them?
My lord.
Is it? Be a little bit more proactive. Get some contact number of the departments in this center so that you can inquire as to what is going on, isn't it? At the time when you were appointed, made a council, a CGC, you must be having some contact number. Find out from them. Anyways, again, to obtain instructions. Yes, both the parties are duly represented. Ms. Adam Sankwe, learned counsel for respondents number?
1, 3, 4, 5, 8, 9, and 10.
Yes, 1, 3, 4, 5, 8, 9, and 10. Submits that she may be given further time for filing of the counter affidavit since she has yet to receive instructions from the respondents. Stop. Then,
Similar prayer on behalf of the state respondents, my lord.
Mr. Samuel Changte,
2, 6, and 7.
additional PP, has also prayed for further time to file the counter affidavit. In view of the above, list after 3 weeks.
On the same date, if not inconvenient, my lord.
Okay, on
13th.
13th,
13
12,
December.
20. Yes.
Deeply.
Like,
Item 12.
My lords.
Yes.
My lords, Mr. Johnny, who is the standing counsel for the, my lords, department, the respondents, he has personally informed me he has received notice, but my lords, I believe he's on leave.
Okay, then we'll have to pick some other.
Yes, my lords. As such, my lords, the notifications, they've been issued by the central government in our favor. So, my lords, I have those notifications, but I'll put them in my rejoinder, my lords, at the specific time.
Heard Mr. Jordan Roghingthanga, instead of that, say Mr. Jordan Roghingthanga, learned counsel for the petitioner is present, while none appeared for the respondents. In view of the above, list after
My lords, may make it 2 weeks also. There's no-
2 weeks.
My lords, the interim maybe.
Is there an interim?
Yes, 19th
Let
September.
me see. When was the interim order passed?
My lords, originally 19 July, that was the first
In the IA? or
in the
what?
IA, my lords.
Okay. Meanwhile, interim order passed earlier shall continue till the next date of this.
Grateful, my lords.
For hearing, item number 30.
Yes. This is a part heard matter.
Well, please, Lordship, my lord, I have authority pass my coordinate bench of this honorable court in connection with
Yes,
CRPC
you
for 2020.
Yes, he has some authorities to place before this court.
Grievance of the petitioner in that case
Now,
is that as per page number 3, para 6, the petitioner was not allowed to know the contents of the award prior to giving her signature on the same. But in the
wait. Let's read the whole paragraph. You're saying page number
3,
3,
para 6,
para 6. Yes,
Yes.
read the whole para, not bits and pieces of the
The learned
sentence.
counsel,
Yes.
The learned counsel for the petitioner submits that despite several sittings before the Lok Adalat, no compromise or settlement was reached between the parties. However, via the impugned award dated 14/3/2020 passed in LA case number 125 of 2018, the Lok Adalat has set aside cancel the village council meeting minutes dated 2nd November 2018, by which the lower portion of the land allotted to Sri Thanchuma was cancelled. Further, the petitioner was not allowed to know the contents of the award prior to giving her signature on the same.
That's your submission, yes. So
Yeah,
what
in
did the learned court say? Read that.
Yes. Ms. Vanessa, the learned counsel for the respondent fairly submits that the Lok Adalat could not have decided the dispute between the parties on merit.
So it's not contested.
As no settlement was reached between the parties, the issue could not have been decided by the Lok Adalat, and the same should have been decided by a civil court.
So in this case,
Yes.
the respondents
Yes.
also said that no settlement was reached.
Yeah.
And therefore, the court, yeah,
Yes.
right?
Right. On perusing the impugned award dated 14/3/2020 passed by the Lok Adalat scholarship in LA case number 125 of 2018, it is seen that the Lok Adalat has exercised power beyond its jurisdiction, and as such, the impugned award dated 14 March 2020 is set aside. As it is a void award, liberty is given to either of the parties to approach the concerned civil court against the decision of North Simluang Village Council sitting number 5 of 2018 dated 2nd November 2018, if so advised.
So is this case applicable in your
Yes,
case?
my lord, regarding exercise of power, because petitioner herein was not a party in the case. So,
In this, he was a party in the case, isn't it?
petitioner herein, in some case, is not a party in the suit. My lord, may I read last
Okay,
order?
I got your point, huh?
Yes,
So you're saying that this is applicable. So,
Yes.
but in this case, it appears that the petitioner was a party.
yes, in the
Here
case of,
it is, he was a party.
yes,
But the respondents said that the court, the Lok Adalat, okay, had acted beyond its
yes,
jurisdiction because the issue was because no settlement was reached between the parties. So in your case also, you're saying that no settlement was reached because you were forced,
Yes.
you were threatened to put
Yes.
your signature. I think that's why you have quoted this
My lord.
case.
My lord,
Otherwise,
may
the
I-
facts are completely different.
My lord,
huh?
may I read order passed by the learned civil judge before the matter,
Okay.
the matter is
Yes.
referred to the
Copy
Lok
of
Adalat,
the,
yes,
huh.
copy. 14/10/2019, plaintiff appear in person, defendant number 1 and 2 are absent without cause. Defendant number 4 appear in person. Due to the absence of defendant number 1 and 2, no hearing could take place. Fixed 25/10/2019 for hearing public appearance of parties. Issue summon to defendant number 1, 2OC Bongkon PS, and defendant number 2, 2OC Aizol PS. Then next,
Okay, this is your case.
my lord, yeah.
Okay.
My lord, this next there is 7 November 2019. Case record received from Lok Adalat along with the term of settlement. Case is disposed of in accordance with the terms of settlement. Decree shall be drawn accordingly. That is the end of the order sheet. So, at no point of time, petitioner herein is impleaded as a party. Whatever is mentioned in the Legal Services Authority Section 20 is a party, but petitioner is not a party in that case. So her appearance, she was forcefully
Yes, yes, I got your
made to
point.
appear before the Lok Adalat. Moreover, she was not, she cannot understand English. Before she appended her signature, the terms and conditions written in English was not explained to her knowledge. She was forcefully made to append her signature, after which she made to leave the room. So the case is, the award passed by the Lok Adalat is liable to be set aside and questioned. The matter be put on trial before a civil court in the interest of the parties.
Yes, got your point. Yes.
May I please, Lordship? Yesterday, I have made my submissions to your Lordship, and if need be, I would like to repeat some of those submissions I have made on the basis of the provisions available in the Legal Services Authority amended provision, my Lord. To begin with, I'm reading with the Lordship permission the Legal Services Authorities Amendment Act 2002, Section 22D. This is the amended provision, my lord.
Wait, let me see.
22D.
B.
D.
D.
My lord. D for Delhi.
Yes.
lord.
Of
Procedure of permanent Lok Adalat, with lordship permission. The permanent Lok Adalat shall, while conducting conciliation proceedings or deciding a dispute on merit under this act, be guided by the principles of natural justice, objectivity, fair play, equity, and other principles of justice, and shall not be bound by the Code of Civil Procedure 1908 and the Indian Evidence Act 1872. On this basis, on the basis of this provision, my lord, I have made my written objection, which I have read out yesterday, my lord.
Okay, so permanent Lok Adalat
Yes, my
means
lord.
Lok Adalat established under Section 22B.
22D, my lord.
No, what does 22B say?
The
B. See, you're
22B.
reading the permanent procedure
D.
of permanent Lok Adalat. Okay?
Yes, my lord.
Now, what is permanent Lok Adalat? 22B.
B,
B. AB.
my lord, my lord. Should I read?
Yes.
Establishment of permanent Lok Adalats, notwithstanding anything contained in Section 19, the central authority, or as the case may be, every state authority shall, by notification, establish permanent Lok Adalat at such places and for exercising such jurisdiction in respect of one or more public utility services. And
So
for
it is
such
for
areas,
public?
my lord,
For one or more public utility
yes, my lord,
services.
and for such areas as may be specified in the notification. My
So
lord.
where's the establishment of permanent Lok Adalat? Because what is public utility? Public utility will be electricity, okay, matters,
My lord, I understand.
and other matters. So whether the instant Lok
My
Adalat
lord.
which we have here is a public, a permanent Lok Adalat. And the permanent Lok Adalat will be headed by, if you look at A,
Oh,
22B to A.
this is concerning about the pre-litigation, my lord.
So where's the but is this a pre-litigation matter?
No, my lord, not. So I'm reading provision section 22, my lord.
Yes.
Section
just
22.
make that clear. Section 22.
Powers of Lok Adalat or permanent Lok Adalat, my lord. The the Lok Adalat or permanent Lok Adalat shall, for the purpose of holding any determination under this act, have the same powers as are vested in a civil court under the Code of Civil Procedure 1908. Well trying
Yes, so the instant case is Lok Adalat, not permanent Lok Adalat.
Yes, my lord.
Okay, yes, then read.
Yes, namely the summoning and enforcing the attendance of any witness or examining him on oath. Number B, the discovery and production of any document. C, the reception of evidence on affidavits. D, the requisitioning of any public record or document or copy of such record or document from any court or office, and such other matters as may be prescribed. Number 2, without prejudice to the generality of the powers contained in subsection 1, every Lok Adalat or permanent Lok Adalat shall have the requisite powers to specify its own procedure for the determination of any dispute coming before it. Number 3, all proceedings before a Lok Adalat or permanent Lok Adalat shall be deemed to be judicial proceedings within the meaning of section 193, 219, and 228 of the Indian Penal Code, and every Lok Adalat shall be deemed to be a civil court for the purpose of Section 195 and Chapter 26 of the Code of Criminal Procedure 1973. And coming back to Section 20, cognizance of cases by Lok Adalat, Section 20,
Yes.
Clause 4, my lord. Every Lok Adalat shall, while determining any reference before it under this act with utmost expedition to arrive at a compromise or settlement between the parties, and shall be guided by the principles of justice, equity, fair play, and other legal principles. So, my lord, accordingly, taking into account the provisions which we have just read out, the impugned award made by the Lok Adalat was made between amongst the parties, my lord, and they all have signed the said award, as we can see from the copy annexed along with the petition, my lord. Here, all of them have signed the award in agreement with the award. And my lord, as I have noted, pointed out in my objection, that the award was signed on 26/10/2019, 26 October 2019, it was signed, and the present instant petition was filed before the High Court on 5 April 2022, after almost 3 years. My point and my submission to your lordship
What
is,
by limitation or what? Is this a civil revision petition?
yes, my lord, it's a civil revision petition. There is a delay, my lord, according to the counsel for the petitioner, she was aggrieved, she was forced to put her signature in the said award. If that in that case, she could have come earlier. And in the revision petition, there is no explanation of the delay in filing the instant revision petition, my lord.
What is the limitation period?
There is no limitation
Then-
period. However, my lord, I have a Supreme Court ruling with me here. There is no limitation period for filing the application under 227. At the same time, the Supreme Court has stated, in the case of Bithika Majumdar and another versus Sagarpal and others, reported in 2017, Volume 2, SCC, page 748, para 4, my lord. Para 4.
Yes.
With lordship permission, it is an admitted position in law that no limitation is prescribed for filing application under Article 227 of the Constitution. Of course, the petitioner who files such a petition is supposed to file the same without unreasonable delay. And if there is a delay, that should be duly and satisfactorily explained. In the facts of the present case, we find that the High Court has dismissed the said petition by observing that though there is no statutory period of limitation prescribed, such a petition should be filed within a period of limitation as prescribed for application under Section 115 of the Civil Procedural Code. This approach of the High Court cannot be countenanced. As mentioned above, in the absence of any limitation period, if the petition is filed with some delay, but at the same time, the petitioner gives satisfactory explanation thereof, the petition should be entertained on merits. In the present revision application, there is no explanation at all of the delay in filing the present petition.
Okay, how many years? 3 years?
Almost 3 years, my lord.
Okay.
And according to the submission made by the learned counsel for the petitioner, my lord, she was aggrieved. She was made to put her signature under force or coercion. However, why did she take this long to file the present revision petition. So, since due to absence of any explanation in the revision petition, the present petition is liable to be dismissed outright, my lord. And my lord, some more rulings I would like to place to your lordship. State of Punjab and another, Jailer Singh and others, reported in 2008, volume 2, SCC, page 660, para 12.
Yes, so we'll have to look into the contents of the award also. Anyway, read para 12.
My lord, para 12 with lordship permission. It is true that where an award is made by the Lok Adalat in terms of a settlement arrived at between the parties, which is duly signed by the parties and annexed to the award of the Lok Adalat, it becomes final and binding on the parties to the settlement and becomes executable as if it is a degree of a civil court, and no appeal lies against it to any court. If any party wants to challenge such an award based on settlement, it can be done only by filing a petition under Article 226 and or Article 227 of the Constitution, that too on very limited grounds. But where no compromise or settlement is signed by the parties and the order of the Lok Adalat does not refer to any settlement, but directs the respondent to either make payment if it agrees to the order or approach the High Court for disposal of appeal on merits. If it does not agree, is not an award of the Lok Adalat. The question of challenging such an order in a petition under Article 227 does not arise. As already noticed, in such a situation, the High Court ought to have heard and dispose of the appeal on merit. My lord, as per this ruling, there is no question of filing the present revision petition, as there is a settlement between the parties, amongst the parties, my lord, as they have put their signatures. All of them have put their signatures, my lord. And one last ruling I would like to place. This I should have placed earlier. Radishyam and another, this is regarding the jurisdiction under Article 227 of the Constitution, my lord. Radishyam and another versus Chabinath and others, reported in 2009, volume 5, SCC, page 616, para 31, my lord. Para 31.
Yes.
Under Article 227 of the Constitution, the High Court does not issue a writ of certiorari. Article 227 of the Constitution vests the High Courts with a power of superintendence, which is to be very sparingly exercised to keep tribunals and courts within the bounds of their authority. Under Article 227, orders of both civil and criminal courts can be examined only in very exceptional cases when manifest miscarriage of justice has been occasioned. Such power, however, is not to be exercised to correct a mistake of fact and of law. Well, my submission to your lordship is there is no miscarriage of justice in the present
So we'll have
Case,
to
my
look
lord.
into the award that is made, whether it seemed as if in the terms of the award that is made,
My lord.
there appear to be a manifest miscarriage of justice. So you can take this court to the award.
My lord,
Anyway, sir,
my submission to your lordship is there is no miscarriage of justice.
so, what is the nature of
As
the award?
such, my lord, as such, the ruling passed by the Supreme Court can be taken into account, and the present revision petition can be liable to be dismissed outright, my lord. With that, and my lord, I have
Let's look at the award. What sort of
My
award
lord.
has been made by
Award-
Lok Adalat? Huh?
yes, my lord.
Let's read the award and see whether
Award-
they appear to be a manifest
My lord, my lord.
miscarriage of justice.
Right, my lord. At Annex 1A is the
Yes, yes.
type copy. It will be easy to read, my lord. I'm reading with lordship permission. The award. The dispute between the parties having been referred for determination to the Lok Adalat and parties having compromised settle the case matter, the following award is passed under the terms and settlement. That the OP number 3, Srimati Sangluri, wife of Pachunga, Polosip, Venglai, shall redeem the LSC number 571 of 1978 from OP number 4, Srimati Zonuni, Special Officer, Social Welfare Department, Government of Mizoram, Lakwitlang, Aizol, by paying rupees 5 lakhs only with interest at the rate of 9% per annum, to be calculated from the month of June 2008 till payment in full. Payment for redemption shall be completed within 3 months from today. On redemption, the OP number 4 shall release the said LSC number 571 of 1978 to the petitioner, Srimati Sri H. Lalmingoya of Mission Veng Aizol, without any delay. The parties are informed that the court fee, if any, paid by any of them shall be refunded. My lord, this
So
is the award.
who is the petitioner here? Opposite
The
party
petitioner
number?
here is Sang Luri, my lord. Sang Luri is the wife of
Defendant number 3.
defendant number Pachunga. Yes, my lord. Second para, the name of the present petitioner is reflected. The OP number 3, Srimati Sang Luri, wife of Pachunga.
Okay, so
Policy.
you are OP number 3, is it?
Yes, my lord.
Petitioner's
so-
husband was
Huh,
OP number 3.
You are OP number 3 and you are to redeem an LSC from OP number 4. OP number 4 is respondent number?
4.
Instant respondent number?
4.
Okay, you are the one. Okay.
Yes.
So you are in possession of the LSC, which you are supposed to return back to the present petitioner. On the petitioner paying you rupees 5 lakhs, isn't it?
Right, my lord.
And once the present petitioner gets receives the said LSC, the said LSC will be given to someone else. Who is Mr.
LSC, LSC
who is-
Lalming Moya.
Who is Lalming Moya?
Lalming Moya
Has he come
is,
today?
uh,
Is he represented today?
He is the
No.
respondent number 1 in the present petition, plaintiff.
Unrepresented.
he is not representative.
He is the plaintiff and Eric
They
is
are not
respondent number
interested in the
Yes, it
matter.
seems so.
Service upon them, upon respondent number 1 and 2 complete, my lord. As we have read out from the order sheet yesterday, my lord.
So you're keeping an LSC,
Yes, my lord.
you're keeping an LSC, which you receive, you refuse to give to the respondent number 1 who is not present, unless the petitioner gives you 5 lakhs.
5 lakhs.
So the person who is aggrieved should be respondent number 1.
My
He's the
lord.
one who wants the LSC back.
After this Lok Adalat award is made, my lord,
Uh-huh.
in terms of the Lok Adalat award, as already observed by this court, my lord, the
Yes.
instant petitioner is liable to pay me rupees 5 lakhs, and thereby he'll redeem the LSC, and the liability lies on the instant petitioner. And this
Now, supposing,
Lord.
I mean, because the facts of the case seems to be a little bit complicated. But supposing you refuse and you keep the LSC with you, okay, and you don't receive the money. So you have the LSC with you. And now this LSC is to be given to respondent number 1 who is not represented today.
Yes, my lord.
So what happens? The respondent number 1, is he going to suffer or what? What is?
Obviously, he will suffer.
So now you are saying you belong to this, you have the LSC, so the landed property belongs to you, which is presently occupied by respondent number 1.
Correct.
So the civil suit is for the eviction of respondent number 1, is it?
No, my lord. The plaintiff, respondent number 1 is the plaintiff, and praying for redemption of the LSC.
He
And on
wants
the
the
other hand, I
LSC.
have also filed counterclaim.
Okay.
And after passing of this award, my lord, I have filed execution case which is pending before the lower court, and that is filed in the year 2022 February. And only after filing the execution, the instant petitioner wake up and approach this court by way of filing the instant petition, after keeping silent for almost 3 years.
Okay. Now, at the time when the execution petition, whatever was filed, was he ever made a party, the instant petitioner?
Yes, my lord.
He was made a
Yes,
party?
my lord.
Okay.
In the execution case, my lord, as already held by the award, Lok Adalat award, the instant petitioner is the judgment debtor.
Okay. So it is after the execution, what order was made,
Yes, my lord.
the matter was referred to Lok Adalat. Is it?
No, my lord.
After
During
execution-
pendency of the civil suit,
The
during
matter was
penden-
reserved,
referred to Lok Adalat.
Lok Adalat. Okay. Then,
And the Lok Adalat award was made on 2019.
okay, so the Lok Adalat, okay, execution of the Lok Adalat award.
Yes, my lord.
Okay, that's when, okay. So at the time of the execution of the Lok Adalat award, when was the order passed, execution of order?
Execution is still pending.
But an order must have been passed?
No, my
Nothing?
lord. What I mean to say is that after
He
filing
was
the
made a
execution.
party.
Yes, my
Okay.
lord. After receiving notice from the execution court, he approached this court by filing this writ petition.
Okay. So
And
cause of
moreover, the
action-
instant petitioner, she is a government employee, government servant, working under Health and Family Welfare Department. She's a matured woman and
Okay, so
educated.
if you can give some explanation regarding the award, the nature of the awards, to see whether this award itself, there is some manifest injustice or something in this irregularity.
No, my lord. No, my
Okay,
lord.
so let's see the award with the background. I think we have to look into the facts of the case then. Whether by passing this award, there can be a manifest miscarriage of justice in the nature of the award. Okay, yes.
The OP number
So,
3.
Yes, just 1 minute.
Yes, my lord.
Why is the present petitioner made to redeem the LSC? There must be some background in this.
The contention before the National Trial Court is that, my lord, the defendant number, in terms of the civil suit, my lord, the defendant number 1 and 2, who are here in the rate as respondent number 2 and 3, had borrowed these rupees 5 lakhs from respondent number 4 by,
From you?
yes, my lord, by mortgaging the LSC of respondent number 1 plaintiff.
So the instant petitioner
And
had
that-
borrowed, wait, let me get the facts clear, okay? The instant petitioner had borrowed rupees
No, my
5
lord.
lakhs.
No, my lord.
So how does the petitioner?
He is
come
the
in?
one who utilized the money on behalf of this instant petitioner's husband, deceased husband. The respondent number 2 and 3 had borrowed money from respondent number 4 by mortgaging the LSC of respondent number 1. And that money is for the petitioner.
So now the respondent, Okay, the respondent number one or respondent, who was the husband?
He
Was
is,
the husband ever made a party? No.
yes, my lord. He was now expired. In the civil suit, he was arraigned as defendant number 3.
Okay, and, okay. Now, in the instant revision petition, is he made a party? No.
Which
In
one,
the
my
instant
lord?
revision petition. Is his name mentioned in the instant revision petition?
Name of defendant number 3.
The husband of the petitioner? No, because he's passed away.
He is no more.
Okay, okay, fine. So your claim is that since her husband had borrowed the money, she has utilized the money.
Yes, my lord.
And therefore she has to pay the, okay, fine.
And she agreed in the Lok Adalat award that is the reason she put her signature in the presence of all these board member conciliators, including the judicial officers. And this was back on 2019, October 26th.
Now, in which year was the money borrowed by the husband of the instant petitioner? I think we have to look into the facts of the case, whether there is some miscarriage of justice in making the instant petitioner pay the rupees 5 lakhs.
It was in the year 2008.
In the year 2008, 5 lakhs was borrowed by the husband.
Yes, my lord.
And when did the husband die? You see, because there are very limited grounds to interfere with a settlement in Lok Adalat, but let's see if there can be some ground.
My lord, although I do not have personal knowledge, but in the instant revision petition at para 2, instant revision petition para 2, third line from the bottom, the plain respondent number 1, Pachuma was expired on 10/10/2010.
10/10/2010. So the money, 5 lakhs, before he died, okay, 5 lakhs borrowed in 2008, however, he died in 2010.
Yes, my lord.
So this thing is that the instant petitioner must have utilized the money since the husband died soon after he borrowed the money. Is it? Yes. Okay, I'm getting the picture. So now, since the husband died and so they had mortgaged the landed property. Is it LSC? It's
Yes, my
because
lord.
of that you have it in your hands. with
Yes,
you.
my lord.
And in the meantime, now the present respondent number 1, who is
Plaintiff.
supposed to receive the LSC, how does he come into picture?
Present
He is the
respondent
plaintiff.
number 1 is owner of that LSC.
Respondent number 1 is the plaintiff.
Okay, the petitioner is not the owner of the LSC.
He is only utilizing the money.
So the owner of the LSC is also not the instant petitioner, but she goes and but the LSC belonging to someone else has been mortgaged.
Yes, my lord.
My lord, Zauchwana, father of respondent number 1, was the registered owner of LSC 57 of 1978, and his LSC was borrowed by defendant public respondent number 2 for borrowing money from respondent.
And she utilized it.
Utilization of the said loan amount is beyond the knowledge of the revision petitioner. Defendant number 4, petitioner number
But
defendant,
let's see, but in the Lok Adalat, only 3 persons have signed their names.
even respondent number 4 is not present.
Yes, now in the Lok Adalat, let's have a look at this again.
Than moi lal kumi sang lure it's lal ming moya.
Now, the petitioner H. Lalming Moya is H. Lalming Moya present at the Lok Adalat? Yes, he is here. He signed his name.
Yes. Than moi defendant number 1 also present.
So anyways, huh, let's make your presentation.
Yes, my
Your
lord.
submissions. Huh.
Yes, my lord. My lord, this the impugned Lok Adalat award was made on 26/10/2019, and in terms of the Lok Adalat award, my lord, the instant petitioner is liable to pay make payment of rupees 5 lakhs to the respondent number 4 within a specified period of time. And the main grounds, as already submitted by the learned senior counsel, my lord, is that he was made to put signature on the said award by way of force and coercion. But in spite of that, my lord, he's slipping over his right for about 3 years. And there's a delay in latches, although there is no specified time limit for filing the revision petition. But this is clearly a case of delay in latches on the part of the petitioner, and as already provided by the learned senior counsel, as laid down by the Honorable Supreme Court in the case reported on 2017, Volume 2 SCC 748. And if I may take a lordship, place this execution petition, which was filed before the learned trial court, just to indicate that it was filed during the February 2022. And it was only after that the petitioner of late came before this honorable court to avoid this proceeding. And there is one order rendered by the High Court of Jammu and Kashmir and Ladakh at Srinagar. Although they are not similarly situated, but in this case, the rival parties were referred to Lok Adalat, and the son of the petitioner, who is not a party, was present in the Lok Adalat, and on the submission of the third party, the award was made. And while executing the Lok Adalat award, the petitioner had tried to turn back, denying his liability. But this court, the court in that case, had rejected the plea of the petitioner therein. It's from para 6, my lord. Before that, my lord, para 2, it will be clear from here.
Yes.
It appears that the respondent number 2 had filed complaints for offences under Section 138 of Negotiable Instruments Act, one against the petitioner and another against his son, before the court of CJM Sophian. The subject matter of the complaint filed against the petitioner was 2 checks, one for amount of so-and-so, and the other for an amount of so-and-so. Both the complaints were referred to Lok Adalat for settlement by the learned CJM, and before the Lok Adalat, a compromise came to be executed by the petitioner and his son, who is not a party, his son, with the complainant respondent number 2 herein. As per the terms of the compromise of the petitioner, the petitioner and his son undertook to liquidate the amount of 8 lakhs by so-and-so by making the payment in 3 installments. I'll skip the remaining portion. And para 3, in the light of this compromise, the impugned award came to be passed by Lok Adalat presided by CJM on so-and-so, and in terms of the said compromise, the complaint against the petitioner came to be disposed of. The petitioner has challenged the impugned award on the grounds that the same has been passed without application of mine and that the same is illegal. It has been further contended that in compromise arrived at before the Lok Adalat, it was clearly indicated that the petitioner did not owe anything to respondent number 2, and it was the son of the petitioner who owed money to the said respondent, but in spite of this, the impugned award came to be passed against the petitioner. I have heard land counsel for the petitioner and produced the record. Para 6.
Yes.
It is a settled law that an award of Lok Adalat can be challenged on limited grounds, and normally an order of Lok Adalat is binding on the parties. It is only if an award has been obtained by practicing coercion or fraud on the party against whom award has been passed that the High Court would entertain the challenge to such an award under jurisdiction under Article 226 and 227. In the instant case, the petitioner has not even made a whisper that he was either made to enter into compromise by practicing any fraud upon him by respondent number 2, or that he was coerced to enter into the compromise with him. The only ground urged by the petitioner for assailing the impugned award is that he did not owe money to respondent number 2, and it was his son who owed the money to respondent number 2, and in spite of this, the award came to be passed against him. And the ground urged by the petitioner appears to be without any substance, for the reason that admittedly a complaint number so and so filed by respondent number 2 against the petitioner before CJM. It is also not in dispute that the subject matter of the complaint was for 2 checks for an amount of such and such drawn by the petitioner in favor of respondent number 2. In fact, the petitioner has annexed copies of 2 checks and memo of so and so with the writ petition. In what connection the petitioner had issued the check in favor of was a subject matter to be decided during trial of the complaint before the land CJM, but during pendency of the proceedings, a compromise came to be executed by the petitioner and the respondent number 2, as also by the son of the petitioner. In the light of the terms of said compromise, that impugned award came to be passed by the Lok Adalat, whereunder the petitioner is obliged to pay an amount of such and such in installments. These all are admitted facts. If at all the contention of the petitioner that he did not owe money was correct, then it was open to him to contest the complaint lodged by so and so against him. But he, instead of doing so, undertook before the Lok Adalat that he would liquidate the amount in installments. This was done by the petitioner without coercion or fraud. The petitioner cannot be allowed to resile from the compromise on a frivolous ground projected by him. Why I'm mentioning this is that, my lord, even this in the proceeding, the son of the petitioner therein was not even a party to the said case. And likewise, my lord, Section 22 of the Legal Services Authorities Act 1987, my lord, Section 22(2), which was already addressed by the learned senior counsel, my lord, which says that without Section 22(2), without prejudice to the generality of the powers contained in subsection 1, every Lok Adalat shall have the requisite powers to specify its own procedure for the determination of any dispute coming before it. So, my lord, the petitioner herein, who had once appeared before the Lok Adalat proceeding and signed on the award with having aware of all the consequences, being a government servant and educated, she cannot.
She's a government servant.
Yes, my lord.
Working as?
Working as microscopist under Health and Family Welfare Department. So, all this award, which is under challenge, there's no infirmity. And only after filing the execution petition, my lord, she had approached this honorable court. So my humble submission is that, my lord, this civil revision petition under 227 against the impugned Lok Adalat award is not maintainable, and it suffers from delay in latches. And the Lok Adalat award was made in terms of the provisions under the Act, and for which the instant revision petition may be dismissed.
Yes, heard Mr. Learned counsel for the petitioner, who has filed the instant petition under Article 227 of the Constitution of India for setting aside and quashing the award dated 26/10/2019 passed by the Lok Adalat, Aizawl District Legal Services Authority under Section 19 of the Legal Services Authorities Act, 1987 in connection with Lok Adalat case number 344 of 2019. The learned counsel for the petitioner submits that the impugned Lok Adalat award dated 26/10/2019 is liable to be set aside on the grounds that the matter was referred to Lok Adalat regarding a civil suit number 6 of 29, which was pending before the court of Senior Civil Judge
Aizawl.
in the said civil suit number 6 of 2009, the instant petitioner was not made a party. Full stop. When the matter was referred to Lok Adalat, summons were issued to her through the what, OC, is it?
No.
Where's the order? Through the OC, Aizawl.
Bongkon.
Through the OC Bongkon, Aizawl. And therefore, she was made to appear before Lok Adalat under threat and duress. He further submitted that the petitioner was also made to sign on the award under threat and duress without understanding the nature or the terms of the award made at Lok Adalat. He further submitted that this matter should be referred back to the Court of Senior Civil Judge, since the award was not in accordance with the principles of natural justice and fair play. And further, the matter before the senior civil judge is at the final stage. What, it is for arguments or what, for judgment?
Before, when the matter was referred, the case was at judgment stage. All written arguments were submitted by the parties.
Wherein the civil suit 6/29 was at its final stage and reserved for judgment by the senior civil judge. Any other point in support of his submission?
With regard to delay in license, the matter was.
Now you're coming up, huh?
Yeah.
Yes. You should have reacted
Para,
instantly.
Page number 8, para 13
Of
of
Yeah.
my petition.
the learned counsel also submits that there was a delay.
Impugn award was received by her on 8 March 2020 only, for which reason she cannot be said that petition was not filed within time.
Where is it in your,
My lord, page number 8, para number 13.
okay, the learned counsel for the petitioner further submits that the award passed by Lok Adalat was delivered to the petitioner only on 08/03/2022, and therefore the instant revision petition was also delayed. No, and therefore there was a delay in filing the instant review, civil revision petition. Yes, anything else? The learned counsel has relied on the decision of a coordinate bench of this court in Nekime versus H. Thangsea in CRP 4 2020 dated 23/06/2021, wherein the coordinate bench of this court had set aside the award passed by Lok Adalat by mentioning that the Lok Adalat had exercised powers beyond its jurisdiction. The learned counsel submits that in the instant case, the Lok Adalat had also exercised its powers beyond its jurisdiction by exercising coercion and threat in making the petitioner put her signature on the award, impugned award, okay, dated, yes, it's in dated 26/10/2019. Anything else? Then Mr. L.H. Shima, learned senior counsel, assisted by so-and-so, Rutlal.Fedi, submits that the impugned award is dated 26/10/2019. However, the instant petitioner has approached this court only on 05/04/2022, and there is almost 3 years delay in approaching this court under Article 227 of the Constitution of India, wherein no explanation has been given for the said delay. He further submits that there are limited grounds for setting aside an award which is passed in the Lok Adalat and on reading of the award, there is no manifest miscarriage of justice. The learned counsel submits that the Lok Adalat as per Section 22 of the Legal Services Authorities Act, 1987, has the power to summon and enforce attendance of any witnesses and examine him thereof, and also have the power to specify its own procedure for the determination of any dispute coming before it. In terms of the said cause, the instant petitioner was also summoned, and being an adult lady, she cannot be said to have been forced or made to put her signature under threat. The learned senior counsel, in support of his submissions, has cited those three cases. Okay, so and so and so. Anything else? I think that's it. Those are your submissions.
Well, one more submission I have omitted to.
What?
Just one more submission, my lord.
An authority to rely on.
Yes, my lord.
Okay, one more authority. The three authorities you rely on. I think we
Hemanta
can-
Kumar versus R. Mahadevaya and others reported in 2022, volume 8, SCC, page 140, para 11, my lord.
What does it say?
Para 11, in view of the above, the High Court has committed a grave, serious error in setting aside the consent decree dated 18/8/2007, passed in the Lok Adalat, which was presided over by the very learned trial court judge. The impugned judgment and order passed by the High Court is unsustainable, both in law as well as on facts, my lord. This
Read the previous paragraphs also. Let's see how did the how did the apex court come to such a finding? There must be something in the facts. What are the facts?
the facts of the case in this.
So the opinion of the court was that since it was presided over
by the learned
trial
court
judge.
trial judge.
So what was the allegation here? That he was forced, signature was put under threat, or what? What are the facts of this
that
case?
is not possible, my lord.
No, facts of this case which you have just read out.
My lord.
Was he made to put his signature under threat or something? Allegation?
No, nothing of
What,
this
what are
sort.
the facts of this case here?
This ruling, my lord.
Ah,
All of them signed before the Lok Adalat, and in spite of that, the High Court set aside the consent decree dated 18/8/2007, and the order passed by the High Court has been set aside by the Supreme Court, my lord.
so just why was it appealed against? The settlement, on what grounds was it appealed? The settlement which had arrived in the Lok Adalat.
On the ground that matter was referred to Lok Adalat by the trial court, and such a ground cannot be approved for doubting genuineness of the consent decree, my lord.
So
The facts in brief
they
is there.
said that the degree was made without the consent of one of the parties.
My
most
lord, that is
probably.
what they have alleged.
Okay. Yes, so
And my contention in this case is, since it was presided over by the learned trial court judge, forcing the party to put her signature
Learned
is not
Senior
possible.
Counsel has also cited this instant case, okay, 2022 case, by mentioning that the Lok Adalat was presided over by a learned trial judge, and therefore the issue of there being any threat or coercion at the time when the petitioner was made to put a signature does not arise. Yes. Then Mr. Victor L. Ralte, learned counsel for respondent number 4, submits that as submitted by the learned senior counsel, no explanation has been given for the delay in filing the instant civil revision petition. He submits that the civil revision petition was made only after an execution case number 11/2022 was registered and notice was issued to the present petitioner. He submits that the instant petitioner had no grievance against the award at the time of passing the award, but had approached this court only on receiving the notice in the execution case number 11/2022. The Land Council further submits that the instant petitioner is a government servant working as a
Microscopist.
microscopist under the Health and Family Department, and therefore she is able to understand the nature of the award passed and the consequences in putting her signature in the impugned award. The Learned Council has also led this court to the terms of the award dated so and so, wherein it was decided at the Lok Adalat that the petitioner should repay him the sum of rupees 5 lakhs, which was borrowed by the deceased husband of the petitioner. And at the time of borrowing the said rupees 5 lakhs, the deceased husband of the petitioner had mortgaged the LSC number 571 of 1978. In terms of the award at Lok Adalat, once the said sum of rupees 5 lakhs was paid to him / respondent number 4. The respondent number 4 would release the said LSC number 571 of 1978 to the present respondent number 1, against whom the said mortgage LSC number 517 of 1978 is mutated. That's it. It belongs to him. The Learned Council submits that even on reading the award, there is no manifest miscarriage of justice, since he is entitled to receive the your money, isn't it? The rupees 5 lakhs which was borrowed by him, and the rupees 5 lakhs is utilized by the petitioner, being the wife of the person, Mr. Who? What's his name? Pachonga, late, who had borrowed the rupees 5 lakhs. Anything else?
My lord, since my learned friend had made further submission, I would like to make a reply in respect of para 13 of his revision petition.
Wait, just before that, the Learned Council has relied on now those 2 judgments. Okay, so that we don't forget 1 and 2. Yes, then?
My lord, my learned friend had make further submission in respect of para 13 in his revision petition, which stated that the impugned award passed by Lok Adalat Aizawl was delivered to the petitioner on 8/3/2022 only, and as such, the instant petition is filed within reasonable time. In this regard, my lord, from bare perusal of the execution petition, which was filed in the month of February 2022, this 8/3/2022 claim by the petitioner is upon receipt of the eviction notice in the execution proceeding, and it is not denied that she had, however, signed on the award. It is not disputed that she had signed on the award, and it
You
is.
said she signed under threat.
Yes, my lord. In any manner, my lord, she had not denied that she had signed on the award. That means that she is aware of the existence of the award, however it may be. And this particular paragraph cannot be sufficient ground regarding the delay. And that it is practiced in the award, in the Lok Adalat, that all the concerned parties were given these copies of the award.
No, that we don't know. Anyways, the learned counsel further submits that the explanation given by the petitioner that a copy of the award was received by her at a belated date on 08/03/2022 is not sustainable, since the petitioner had put her signature on the award on the same day itself, and therefore she is well aware of the terms of the award. Yes. Now, we'll make it a CAV. I'll consider the authorities which you had relied upon. Okay, and then thereafter only I'll come to a decision. Yes. Heard Mr. In the main order, heard Mr. Levin Cronin, learned counsel for the petitioner, along with Mr. L.H. Nyanchima, learned senior counsel for respondent number 3, assisted by Ms. Ruth So-and-so, and Mr. Victor L. Ralte, learned counsel for respondent number 4. Hearing is complete. Matter is reserved for judgment.
For order, unlisted case, bail application number 79 of 2024.
If I may please, Your Lordship. My Lord, this is bail application for bail conditions modification, which Your Lordship has already passed the order on 26/9/2024. And then, my
Yes.
Lord, this Honorable Court's order dated 26/9/2024 was submitted to the learned special judge for execution of bail bond. And the learned special judge had imposed certain conditions, which we have annexed in annexure number 2, my Lord.
So did you approach
Yes, my Lord, I did.
the trial court concerning the conditions?
Yes, my Lord.
What are the conditions? Let's see.
My Lord, it's at page 14 and 15. Must be permanent resident of Aizawl, living in his own house and not on rented house, and the other must be the family member of the accused. This, my Lord, we have it. We have LSC, and the paternal uncle who is living in Aizawl is another bailer.
Yes.
Sureties, we can show this, my Lord. Number 3, sureties and the accused shall furnish photocopy of his Aadhaar card, EPIC, and family ration card. This, my Lord, both the sureties have it, but the accused did not have it because because of his religious beliefs. So, my Lord, our humble prayer before this court is that we have a local council acknowledgement with the house number.
No, but because of his religious belief, he doesn't have Aadhaar
Yes,
card.
Aadhaar card
Does
and
he have
family
an
ration
EPIC
card. The sureties, though they have it.
Oh, what about the accused? Does he have an EPIC card?
No, my Lord, he doesn't have any.
What about family ration?
No, my Lord.
what sect does he belong to?
They said, hey, how do I say?
Okay, if you can express better in a Mizo language, what?
Hey, other sakol lao ang chika. Sakol lao ang chika.
Okay.
Hey, other card ne do lao ang chika.
So they may not have an Aadhaar card,
Yes, my
but they
lord.
must be having some epic or family ration card at least. Let him produce a ration card at least.
My lord, he doesn't have, but they have this acknowledgement. They can take it from any YMA or local council. And all the others we can.
So did you make a submission before the learned trial court regarding this, that we don't have these, but maybe if we can produce this, kindly accept that something?
Yes, my lord, I did. One of my juniors also met the special judge, and I also met her again. And she said that yes, but I've already passed the order, so I cannot modify my order. So kindly approach the High Court. The High Court will modify it.
Okay, so we'll make it as such or any other. Okay,
No,
without
that
modifying.
all the other
Or-
conditions we can
yes,
fulfill.
so all the conditions, but we will say, or we will modify this part of the condition, say the or any other document, okay, showing that the accused is a resident of which place? Which place?
Zokotar.
Zokotar.
Yes, my lord.
We'll make it that. We'll make it as simple, isn't it? Yes.
Yes, my lord.
You accept notice today, and then
yes.
we have heard both of you, isn't it?
Yes, my lord.
Heard Ms. Ngaisake. Then Ngaisake.
My lord, can I make one submission?
Yes.
Yeah, my submission is that, my lord, if we are going to modify this condition which the learned trial court had required, so my lord, in order to prove that he is a citizen of India, at least he should have that Indian citizenship passport. So
No,
if-
they cannot have Indian citizenship.
my lord,
passport.
if he cannot have the Aadhaar card and
So
Epic
a letter
card,
from the authority, some letter to satisfy,
that
to
authority-
satisfy the trial court that he is a resident of that place.
Yes,
Isn't
my
it?
lord.
Let the trial court do
to
the homework.
satisfy the learned trial court.
yes.
Yes, my lord.
I heard Ms. Vanda Ngaisake, learned counsel for the petitioner applicant who has filed the instant application under 483 BNSS to relax/modify the bail conditions imposed by the Judge, Special Court of NDNPS Act, Aizawl District, in its order dated 14/10/2024. Full stop. The learned counsel submits that bail was granted to the petitioner via this court's order dated 26/09/2024 in bail application 72/2024, wherein this court, while granting bail, had mentioned that the petitioner is granted bail with a bail bond of rupees 1 lakh and 2 reliable sureties, each with bonds of the like amount and reliable sureties, who shall be to the satisfaction of the learned special judge and the NPS Act. Full stop. In terms of the sale order, the learned special court and the NPS Act had imposed a condition that in its order dated 14/10/2024 at serial number 3. Okay, this will be within inverted commas. Sureties and the accused shall furnish photocopy of her/his Aadhaar card/Epic card and family ration card, full stop. Close inverted commas. The learned counsel for the petitioner submits that the petitioner is not able to furnish any of these conditions by stating that he does not have his Aadhaar card or Epic card or family ration card due to his religious beliefs, wherein he had refused to get himself registered to obtain the said documents. The learned counsel therefore submits that the said conditions made at serial number 3 may be modified. I've also heard Ms. Isyami, learned additional PP, who has accepted notice on behalf of the state respondents. The learned additional PP submits that if the said documents cannot be produced, he should be able to produce at least a passport or some other document. Full stop. Having heard the submissions made by the learned counsels for both the parties, this court find it appropriate to modify the terms made at serial number 3 in the order dated 14/10/2024. What is the number? In SR number 417/2023. By stating that the accused may also furnish any other document duly certified by either the local leaders that the petitioner is a permanent resident of Zokathar village. The said document shall be subject to the satisfaction of the learned special judge and the NPS Act. Accordingly, the said bail application number 79/2024 stands allowed and disposed of as above. Yes.
Deeply obliged.
Part 2, item number 8.
Yes, none appeared for the parties on call. This after 2 weeks. Now, there was one matter that was mentioned. Is it ready? Pardon? Okay, so we'll hear the other matter at 2.
Yes, my lord. May it please your lordship, this FAO has been filed against the impugned order dated 21/10/2024. If I may read.
Yes.
As regarding the prayer for ad interim injunction, I am not inclined to grant prayer for ad interim injunction without giving opportunity of hearing to the defendants, issue notice to the defendants or peace to show cause as to why the prayer of the plaintiff shall not be granted. And at paragraph number 5, fix 20/11/2024 for appearance and submission of written objection by the defendants or peace. So, at this stage, a notice for eviction has already been served. And though we were not served, the borrower, the loanee, has been served a copy of the eviction order, which is at page 22, my lord. Page 22 of my FAO. As per this, we were to vacate the landed property along with our house on or before 23/9/2024. However, luckily till date, we have not been forcefully evicted.
No steps have been taken till date.
Yes, because of some problems in the office of the deputy commissioner.
No,
it
the
seems.
date is already expired. It's 23/9/2024.
Yes, on or before. So at this stage, we are
On or before.
likely to be evicted at any stage, my lord, because no notice has been served to us. Due to this notice, we have filed the case, my lord. And after filing the case, since no injunction has been granted, we can be evicted from our house at any stage. So, my main grievance is that the principle of natural justice has not been followed in the case, because I am the owner of the LSC.
That we'll have to see. I don't know whether you're the owner or
A
not.
perusal of
but
the
yeah.
page 22 would clearly shows that, my lord, I am the owner of the LSC, because it is written herein that the owner of the LSC is Silal Biaktanga, and the notice was served to TB Silal Lomzwala, who is the respondent number 5. Though I am in occupation of the property in question, no notice has been served to me, and my landed property was mortgaged without my knowledge and consent. And my case before the Court of Civil Justice Senior Division, Champai, is that I am not a guarantor. I did not execute any mortgage deed. I did not sign any authorization for mortgaging my LSC. And now, it seems the respondent number 4 and 5, in connivance, has tried to snatch away my property. So, if any action is to be taken against me, my lord, at least I should be heard first, my lord. And since no interim injunction has been granted, I can be evicted at any stage forcefully. And the whole purpose of me filing the suit, that is civil suit number 13 of 2024, before the Court of Civil Judge Champai, would be infructuous, my lord.
So what is your prayed for?
My prayer is, my lord, to modify the order dated, impugned order dated 21/10/2024, by granting interim relief to me, even up to a limited period, my lord.
No, till the final disposal.
Yes, till the final disposal of the connected civil suit number 13 of 2024 or CMA number 60 of 2024. And the interim prayer that I've made at page 7 is that I shall not be ousted from my house within the LSC number 3091/15/01/28 of 2015, located at Bethel Vance, till final disposal of the instant appeal. Till final disposal of this instant appeal, man. Because
What is the appeal? Appeal is against what?
appeal is against the impugned order refusing to grant interim injunction.
No, but it has not refused. It has fixed 2011, 2024.
Yes, my lord. I am not inclined to grant a prayer for ad interim injunction means refusal as per the language of the statute, my lord. And 2011,
Till a copy has been given, isn't it?
yes, my lord, 2011, 2024 is far away. And the usual practice in another case also, the court
With
usually
the practice
entertains.
and
Yes.
there's no fix and hard and fast not to practice,
Yes,
please.
my lord.
It is the discretion of the court,
It
how
is
they
the
want to go
discretion of the
about of the
court.
court,
My lord.
Because there's no, it's not a practice, it is the law. They have to see the law, not
Yes.
what is practiced by other courts.
Yes, my lord.
You can't impose that on the other person.
My lord, with regard to ex parte injunction, I have brought a few judgment.
Because this court has not disposed of your prayer.
Has not disposed of,
No,
but it
it's still
refused to
pending.
grant ad interim injunction.
Till hearing of the opposite party,
Yes.
isn't it?
My lord, hearing will not be done because I will be forcefully evicted by then. That is why I come before your lordship.
At this stage, at the most, what we can do is to stay the operation till this date fixed on 2011,
yes.
2024.
Yes, my lord.
Till that only. Then let the court decide whether it wants to, because
Yes.
the FAO cannot be at this stage when the whole matter is still pending before consideration before the learned civil judge, isn't it?
Yes, my lord. Yeah, if your lordship can direct that the appellant should not be ousted till the fixed date, then our problem is solved, my lord. Because
That's how you should pray, because how can I set aside an order which has not refused granting of this thing? Your prayer, it says I'll consider it after giving a chance of hearing the other side.
yes, I am not inclined to grant prayer for an interim injunction, meaning that I can be evicted
Without
anytime.
read
Yes.
the whole sentence, read the whole, not half a sentence.
Yes, my lord, I understand.
Without giving an opportunity
Yes.
of hearing.
Yes, my lord,
Isn't it?
I understand. But by 2011, 2024, we will be evicted from our house.
That's what, so the way you have tried to project it as if it has not been refused, it has not been refused at this stage yet, but he wants to hear the opposite party. That's it.
Yes, the ad interim is refused. Interim is still pending for consideration.
For consideration.
But ad interim has been refused. But interim is still pending.
Interim till the hearing of the other, this thing, till,
Yes.
so it is not granted till 2011, then thereafter it can be seen, isn't it?
Yes, by then I will be evicted, my lord. If your lordship may be kind enough to
Date has been given 29, you're still there. Now it's 10, 2 months, 3 months. How can you say that you'll be evicted by then?
My lord, they are coming for me every minute, my lord. That is why I'm before your lordship. My lord,
23-9.
with regard to this 1994 volume 4 SCC 225, at paragraph number 36.
36.
Yes, my lord.
What does it say?
As a principal, ex parte injunction would be granted only under exceptional circumstances. The factors which should be weighed with the court in grant of ex parte injunction are whether irreparable or serious mischief will ensue to the plaintiff.
All those things have to be yet considered. Yes, yes.
My lord, granting ex parte injunction, if it hurt the other side, it will not be ex parte injunction. Whether the refusal of the ex parte injunction would involve greater injustice than the grant of it would involve.
Yes.
C. The court will also consider the time at which the plaintiff first had notice of the act complained, so that the making of improper order against a party in his absence is prevented. D. The court will consider whether the plaintiff had acquiesced for some time, and in such circumstances it will not grant ex parte injunction. The court would expect a party applying for ex parte injunction to show utmost good faith in making the application. Even if granted, ex parte injunction would be for a limited period of time. General principles like prima facie case, balance of convenience, and irreparable loss would also be considered by the court. Here, my point is number A and B and F, my lord. If I am outset from my house, irreparable loss and serious mischief will be caused to me. I am the plaintiff. And in F, it clearly says, even if granted ex parte injunction would be for a limited period of time. If the learned trial court can grant me an interim injunction till the returnable date, that is on when the parties are to be heard, then I can explain myself. But at this stage, my lord, I am
Yes.
very vulnerable. That is my problem.
Yes, Miss Caroline Kalal, what do you have to say?
And at first, I will have to take instructions from the respondent number 1 to 3.
You see, at this stage, instead of going on with this case, why don't we dispose it off by staying the operation of this order?
Yes, madam.
These are simple matters. Why keep it pending?
Yes, madam.
Dispose of the instant FAO by staying the operation of this impugned order 11 September 2024 till
2011.
Till 2011. Yes, my lord.
till the date in which the respondents are to file their written objection, and then we can say that dispose it off.
Yes,
by
my lord.
then. I think why have this matter pending? It's a simple matter.
Yes,
isn't
my
it?
lord.
Yes, my lord. It can be disposed of in that terms.
Instead of listing it again and hearing the matter when it is still pending before. Now, this is a CMA arising out of a civil suit.
Yes, my
you
lord.
see. Then this civil suit has to be decided. In the meantime, this is just a CMA.
Yes, my
So
lord.
in the CMA, if we keep the FAO pending
It will be
with
pending.
regards to the CMO, again, the case will drag on for a long time, isn't it?
Yes. If I am not outset till the next court date, then I believe I will
By
go
that
forward, my
time, you
lord.
can be heard, the
Yes, my lord.
respondents also will have a chance.
Yes, my lord.
Heard Mr. Yes,
Zoram Chana.
yes, Zoram Chana, learned counsel for the petitioner who has filed the instant petition. / appeal under section 17 within brackets 2 within brackets B of the Mizoram Civil Courts Act, read with section 104 and order 43 CPC, 1908, against the order dated 21/10/2024, passed by the learned civil judge within brackets senior division Champai in CMA number 60/2024, arising out of civil suit number 13/2024. The learned counsel submits that the instead of petitioner, make it appellant, okay? The appellant is the rightful owner of the LSC number 3091/15/01/28 of 2015, located at Bethel Vang, Champai, which was fraudulently mortgaged without his knowledge by whom? Respondent number?
5.
5. Okay, by respondent number 5.
Oh,
Thereafter, due to the non-payment of loan the respondent's number? Who has issued the
The respondent
eviction
number
order?
3 issued the notice.
The respondent number 3 had issued an eviction order dated,
11/9/2024.
it's at page what?
Page 22, madam.
Yes, 11/9/2024. Informing the appellant to vacate the area covered by LSC number 3091/15/01/28 of 2015 on or before 23/09/2024. The learned counsel for the appellant submits that aggrieved by this order, he had approached the learned civil judge within brackets senior division praying for this in the praying for an ex parte order to stay the said eviction order. However, the learned trial court in its order dated
21/10/24.
wait, let me find the order. So
In the beginning, madam. At the beginning.
documents you have filed it only, you have only attached it only in the beginning, certified true copy, while the Xerox copy should also be attached behind, isn't it? That's what I'm searching for. In the order dated 21/10/2024, had refused to grant an ex parte interim injunction by mentioning that the court was not inclined to grant an ad interim injunction without giving opportunity of hearing to the defendants. Full stop. Accordingly, the learned trial court had issued notice to the defendants/opposite parties and had fixed 20/11/2024 for appearance and submission of written objection by the defendants/opposite parties. Full stop. The learned counsel for the appellant submits that since the impugned eviction order has not been stayed, there is every likelihood of the appellant being evicted from his LSC before the said date fixed by the learned trial court. He has therefore prayed for stay of the for the setting aside of the order dated 21/10/2024 passed by the learned civil judge, senior division, or for passing any order found appropriate by the court. Ms. Caroline K. Lungonte, learned government advocate, is present and accepts notice on behalf of the state respondents.
1, 2, and 3, my lord.
1, 2, and 3. This court, after hearing the submissions made by the learned counsel for the appellant, and on hearing the learned government advocate who submits that instead of setting aside the order passed by the learned civil judge, senior division, in the interest of justice, the operation of the eviction order dated so and so may be stayed till the date fixed for submission of written objection and hearing of the parties, that is 2011-2024. Is it okay, your submission?
Yes, ma'am.
Yes, my lord.
Ms. Caroline? Having heard the submissions made by the learned counsels for both the parties, and on considering the nature of the appeal, which is against the eviction order dated so and so, and the apprehension of the appellant that he would be evicted from his LSC number so and so till the next date fixed by the learned trial court, that is on 2011-2024. This court find it fit to dispose of the instant FAO by passing an order that the operation of the eviction order within brackets Shyatirna issued by the district magistrate, Champai district, Champai / respondent number
3.
3 is to be stayed till the next date of hearing of the matter in CMA number 60/2024, which is fixed by the learned senior civil judge on 2011-2024. That's all. The learned senior civil judge may make an attempt to dispose of the CMA 60/2024 expeditiously, considering the nature of the submissions made by the learned counsel for the appellant. Accordingly, the instant FAO number 10 of 2024 stands disposed of as above.
Obliged, my lord.
Oh, yes, your citations, your authorities. Okay,
Yes,
we
ma'am.
can include this. The learned counsel for the appellant has relied on the judgment and order of the apex court in Morgan Stanley Mutual Fund versus Tartik Das, reported in 1994 for SCC 225. Para?
Paragraph number 36.
Para 36. Yes.
Obliged, my lord.